All righty.
On the right slide.
We're just starting to let everybody in. It's 3 o'clock, and we usually kind of poke around for a minute or two to give people enough time to deal with their tech surprises, and there's always some. It never fails. Okay. Okay, so afternoon, everyone. We're just sort of letting folks come on in. Couple things. One, this is recorded, so be aware of that. Number two is you can ask your questions as the presentation goes. Either you can raise your hand, or you can start to talk, or you can put it in chat. And Julie and Kate will try to address all the chats as they come in. If you want to introduce yourself in chat and say where you're from and how long you've been doing it, you can, but we have way too many people here today to actually do an introduction of anybody but our speaker. So 3:01, we're going to give another minute or two. I'll start introducing Michael, and then we'll get on with this in just a minute. So I had the privilege of meeting Michael. I don't know if you guys have saw his presentation. He actually did a presentation at the FSGA conference, which was great, and one of the first times I've heard an attorney talk so clearly about the 825 injunction and about exploitation and about all the things we can now do, which is these are some new tools that we didn't have some years ago, and they really are important that you know that and that your attorney knows it, because not every attorney has done many of these injunctions. So that's sort of that. So if you want to ask a question, you can ask it in chat, and if you want to raise your hand, you can do that too, but you don't have to say anything in chat. It's just up to you. All right. So it's 3:02. Let me do one more minute. And meanwhile, Michael, I'm not going to do much, but just say I think Michael's the right kind of energy and the right kind of guy for exploitation cases, which takes like a certain personality. And Michael's the kind of personality I'm looking for exploitation messes, because you kind of have to be a bulldog. So, Michael, you want to introduce yourself? Tell us a little bit about what you do, and then about 2 minutes of that or so start.
Sure thing. Yeah, I really appreciate you guys giving me a chance to talk to you. I love working with professional guardians. They're some of my favorite clients, and my two most successful groups of clients, now that I'm thinking about it, are probably very passionate professional guardians and first daughters for some reason, like very type A personality, like oldest daughters, very consistent. Um, but when it comes to addressing exploitation or suspected exploitation or undue influence, a lot of that has to do with being able to gather the appropriate evidence and applying it appropriately. So it seems that that would be simple enough, but I didn't realize how complicated it could be until I kind of stumbled into guardianship law. So a little bit about myself. My name is Michael Julian. Had a weird kind of route to ending up being an attorney. I went to college originally to be an airline pilot, but wasn't a great year in 2008. Went to business school, law school, and started practicing as an attorney with the state attorney's office, finishing my contract as a felony trial prosecutor. So after doing that and going to the private sector, I really just couldn't fit in any real niches. Like family law was not really for me. Ticket clinic, none of that stuff. But I got asked to help out on a family case, family friends case, where there's some family members doing things that we're all very familiar with now. And I realized that really what we were doing is just applying the principles of criminal law to a civil arena. And once you figure out that kind of process, it's remarkably easy. Um, I struggle as an attorney. I will admit that in the routine administrative processes of guardianship, it is a very different skill set, process, and area of law. So if you have an attorney who's great but is struggling with this, that doesn't mean anything. It's not surprising at all, because even lawyers and judges who do this for some time have different opinions as to what means what. So we're going to talk today about some tools you guys can use as you go about your day. And when you start noticing something's wrong, or when you know from the get-go something's wrong, and some of the things that you can do that maybe you don't need a judge for, or that can set you up for success, down the line. And
Right.
as I go along, I really want you to put up your hands. If you have something to say, you can raise your hand. I guarantee you, everybody here has a case or a fact pattern that they think nobody would believe. They couldn't pitch it to Netflix, or they can't crack. And I can't give you legal advice, but I guarantee you that you're probably not the one with the craziest story here, unless you have an actual hypnotist. But it seems that the groups get the most out of these when people participate. So let's just get going. So, like I said, we just want to provide some tools that you can kind of use with you as you go about your work. These are things like spotting indicators of exploitation, uh, knowing how to gather evidence appropriately so that people can use them, people like law enforcement, knowing how to articulate your role in this with professionals, like banks, for example, how to navigate their kind of uh, offices and different routines with different orders and recognizing what you can do to compel compliance and get discovery outcomes from essentially discovery outcomes from certain people without having to even do litigation. So once you kind of understand that, you have a leg up from a lot of the people in the same area. A
Right.
very Yeah, a very good example of this. People who want to get out of trouble will volunteer things without necessarily knowing what the implications of that could be. A good example, let's say you get appointed as an ETG or appointed a guardian on someone who you suspect exploitation from someone in the house. Start reviewing records, and this guy is driving around in your ward's car. You go, hey, I'm going to need that. We have to sell it to pay for his care. They go, no, 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 it's fine. He actually sold it to me. Here is the receipt or whatever it is. Here's the registration. Uh, well, he just handed you a exhibit A to his exploitation case because if he knew or had reason to know that the person under his care didn't have the capacity to consent, then that is a very problematic transaction that just occurred, and you can use that to leverage, the settlement or some more stronger relief from the court. Interacting with law enforcement, everybody here has a story of trying to get law enforcement to do something that you thought was very simple. And maybe you dealt with the officer who was frustrated because he wanted to help you, but didn't know how. Uh, I can give you the best tools I have. I cannot say that there's anything particularly consistent. I'll say that if you encounter these things regularly, or if you think that you're going to have the situation, reach out early to the sheriff's department. They're generally the ones who are going to be handling that sort of investigation. They're also the department that's going to be handling service. So, unlike other cases, you need to make sure you have good eyes on the person being served with a potential injunction as opposed to like a different lawsuit. And that has to be done by the actual sheriff.
And Michael, I want to kind of reiterate that I think guardians get hung up when they deal with city police, and nothing goes right with city police in my experience. Sheriff, you got a better chance, but absolutely going in advance, not during a crisis, sitting down with the sergeant or the person who's a little bit above the street folks, so that when you need them, they've already looked at your documents, they've already sent them to legal, they've already talked about it, they understand what you're trying to accomplish. If you just call them from the house when the crisis is happening, you are much less likely to succeed.
Yes, and I think you just touched on something very, very important. Uh, a lot of people will use the term, police, sheriff's department, law enforcement, Leo interchangeably. If you
Right.
are trying to get the court to tell a cop umbrella to do something, you're going to use the sheriff's department every time, everywhere in the state of Florida.
Yeah.
If the police come out and they look at you like you have two heads, that's why they just don't really fall under that jurisdiction. They don't serve warrants of the court. And if you are trying to get a sheriff's deputy to do something that an officer, that a judge is telling them to do, you have to be very specific. That, like, say you need to get into the property, or you need to get somebody out of the property, your lawyer should be aware that they can't just whip up their own order. So I'm not giving anybody here advice on how to draft it. You couldn't do it. Your lawyer probably couldn't either, because most departments have what are called dedicated break orders, or at least a format that they use, so that every deputy is very familiar with the layout. So they don't just have something with a signature on it. Even if it's otherwise legally valid, they may not recognize it because they want to be on guard for forgeries. Um,
Oh, so
yeah,
each department is used to looking at their specific layout of their order. That's the whole point of that meeting
not
ahead of time,
not always,
but
but to
often.
if they're a big department or a big office, so sheriff's
Okay.
office is always, yeah, no,
Okay.
sheriff's department. Never mind.
So
Uh,
the point of that then is maybe in that first meeting, you go ask them what form do they want
yeah,
to see so that your
so
attorney is actually preparing that form.
that's going to be what your lawyer is doing. If you have an
Okay.
issue where you need to get hands on your actual ward, you can consider utilizing fire rescue as well. Very often they're trained in identifying indicators of capacity, and they can pull somebody out of a location on medical grounds at a much lower threshold than law enforcement can. So if you have a good
Okay.
relationship with fire rescue, you can coordinate with them and say, hey, I have a ward and I can't get access to them. I think there's somebody in there, but I have this order that says I'm allowed in this person's house. So police are not going to kick down the door, fire rescue may, and it's much easier for them to pull someone out to get them checked out at a hospital. And once you're there, you have, a lot more say in the matter.
Okay.
Um, and the review of legal options. A lot of people, officers, courts sometimes uh, end up hitting a brick wall when somebody starts throwing around an official looking document or a valid document like a power of attorney, healthcare surrogate, or something like that. And they can utilize that to interfere with your ability to carry out your orders, or they can use it to convince, bankers or something like that, or cops to do this or that. You can also use that to your advantage if you review statute, which if your attorney does this type of litigation. If somebody assumes the responsibility under a document like this, they also assume the responsibility to account for it. So it has a built-in recovery method under the same legal authority that they're using to access assets. So if
Okay.
somebody puts themselves on your ward's account and they say, hey, I was doing it as a power of attorney, fantastic. If you can point to an instance of, self-dealing with that, or something that would indicate self-interested use or cause to be concerned, I don't have the language in front of me. You can have a court compel a very detailed accounting of how those funds were used at their expense. So again, that's a lot of pressure off of you. But again, injunctions can be a tool that can complicate your case unnecessarily if not done properly. Some clerks will
Mm.
say it has to be filed with your existing case number. It does not. It's supposed to be a separate case in front of the same judge. Once you introduce it to your guardianship case, it's going to cause a lot of problems with your administration and just your court flow to try to keep it
Oh,
separate. Uh,
okay. Hey, Michael, are we supposed to be? Oh, there you go. I see the slideshow changing. Go ahead. Keep going.
no, I just got off on a tangent. Sorry. So, what are your responsibilities? Let's think about what you have to do and what's kind of expected of you. There are increasing risks of fraud with this AI stuff. It is shocking what people can fake. You may want to consider and consult with families' safe words. It sounds weird, but
Wow.
there's no
Wow.
indicating this video could be fake. Nobody on this has any idea what I actually look like. So maybe even in the future, you have to consider your hand signal or something.
Wow. I never thought about that. Crazy.
So I would also say, given the state of AI and just what you can do with the agents, like you can program something to just try a million different things until it gets access to somebody's email, and it'll try. You may want to take the time to educate yourself regularly as to what's going on in the state of the art of fraud, because it's not just dial up. It's not just, hey, go get a go get a card, a prepaid card or something like that. Speaking of which, my phone just turned on for some reason. Uh, so something to consider going forward. But again, since you do have this responsibility and you do have these powers from the court, you have a lot more authority to go out and get the most important information, evidence needed to do what's right for your ward. So 415, very low bar to establish what is a vulnerable adult. This is the APS statute 415 as opposed to 825. We don't need to get into the nitty gritty. But 415 is what you would be traveling under if you wanted to get DCF involved. They can get they would end up initiating this type of proceeding. It's very powerful to get these types of findings, and you can also get a declaration of your ward as a vulnerable adult under the statute just during your guardianship if you start trying to recover assets. Let's say somebody's trying to be difficult in returning something. If you have that finding, and this may be more appropriate for your attorney, but if you can get that finding, it can elevate your potential consequences against this person, or the standing and the ability to recover assets.
And is the finding coming from Adult Protective Service generally?
So if it's coming from Adult Protective Service and
camera display.
If they determine someone is a vulnerable adult, they may establish that in their particular petition. If you are going for certain causes of action or recovery options, you might want to have them declare that by the judge.
So the probate judge or Adult Protective Service or both?
It's a matter of fact. The person qualifies that as such. But if you're going to make allegations against someone and you have that declaration ahead of time, you basically have a bigger stick to threaten them with, if that makes any sense.
It does make sense. I'm just not clear on who that determination comes from.
Is
it from
APS when they initiate the action saying this is on behalf of a vulnerable adult, or it could be from the court saying, okay, yes, they are a vulnerable adult, so this gets that enhancement.
Okay.
So these are some of the pieces of evidence that we're all very familiar with. The financial documentation, they are your magic bullets. There's a lot more to those than you may see on face value. As the guardian of your ward, you stand in their shoes as the customer. You're entitled to every piece of information that they are. Does not mean the bank is going to honor this, but since you are operating under a case number, your attorney has the power to issue subpoenas. So if you're trying to get records of just financial statements, that is fantastic. But if you issue a subpoena, you can get a lot more information, like the video of when someone shows up to use a card, down to, in some instances, the IP address of the phone that they use to log into the account, the GPS coordinates of the phone when they did it. So let's say there's a particular transaction that you find objectionable and you issue the right subpoena, you can get the location of the device that did it, and obviously your ward may or may not have been there. One of the great things about financial crimes is that you can't bury a paper trail, not deep enough. It will be found with enough time and effort. And with, again, new AI, it just gets easier. So now I obviously remember the days of literally the pin boards and yarn. Now you can kind of dump a pile of documents into an AI and ask for certain relationships and sending habits, and there you go. One of the key things that obviously everybody here is familiar with that exploiters will do is go to Publix and withdraw that extra cash. It adds up. It doesn't, they're going to show one statement and say, see, okay, that's here or there. If you take the time and you add it up, it is always enough to show a pattern of exploitation, to show that intent. And that I've never seen that not work, in only the worst cases. So getting access to those records early is very, very crucial, but it's also good to remember that they don't exist in a vacuum. So if you're looking at financial statements, it's great to have a number and to say that that transaction was fraudulent or inappropriate or self-interested. But why? All right, so this is the transaction. Here's the medical record showing him in the hospital at the time. He wasn't at the casino. All right, so those two need to go together and they need to go together early so it's clear as to what you're talking about. Because when, if you hand it to your attorney, he's going to spend tens of thousands of dollars trying to figure out why this means what it means in relationship to the bigger picture. So stopping and taking the time, particularly with a Word document, so it's easy to copy and paste, to prepare an outline of who is this person? What did they do? Why is what's wrong wrong? What smells funny? On this date, this happened. Just those notes, having them in one place for everybody involved can be the difference between this case getting looked at this afternoon because the cop has enough time and this one not and goes to the bottom of the shelf. And I can tell you as a prosecutor, like that's how it works sometimes. Um, there's always more files coming in on Monday. You have the time that you have. So the easier you make it for people, the easier you're going to see your case going. I also want to temper expectations with law enforcement intervention. There does not appear to be sufficient funding or training or interest to make this a priority. Um, the
Which is
th-
crazy, crazy.
eh, it, they don't pay taxes. Why bother? Anyway, if you want to be really cynical about it.
Mm.
So that's something to consider. The fact that it is a crime and that it does come with really serious legal penalties is a good bludgeon, especially if they are represented by counsel, because someone can articulate that threat to them. If they're too dumb to realize that this is a serious felony, they're more likely to get away because the system doesn't have enough time to prosecute the very obvious serious felony. Um, so that's something to consider. We've all seen these patterns of control. We've all seen issues with trying to articulate them. So I can't see any hands or faces, but I'm sure somebody's had a client who, um, like, hey, I'm trying to see my dad and they won't let me, or I call and he doesn't answer or something and blah, blah, blah. You go and you can scream it till you're blue in the face to every cop and every judge on the state, and it just doesn't help. Well, because they don't know you. They don't know him. They don't know that person. They're all John Smith. And I like to advise my clients, like everybody here has had to at some point mediate a dispute between kindergartners or people on that emotional level. Think of this like that. Every cop you go to with a problem, every judge you go to with a problem, you are the X number of toddlers with a problem they're seeing that day. Making it easy for them to understand what's going on and being calm and being prepared and having a outline as to why it is concerning that they missed their lunch date today, right? Why is it important
So
to
yeah, Michael, so that's a real struggle because when we have these cases with financial exploitation, which are often pretty black and white, those seem so much easier. But when you get into the emotional and the control and the isolation, exploitation or abuse, it's so much harder. And often we get appointed because of the war between the three kids and everybody stealing grandma from the other and not allowing everybody else to see her. Those seem to be so much harder to actually, because the truth is we actually don't want them not coming to see her. We want her to, she wants a relationship with all these kids, and then they
yeah,
all hate each other. And I think those cases are even more of a challenge than the ones where it's money and assets, because I think it's so
I
much
would
grayer.
I would highly recommend in situations like that when it's the family thing, you're gonna have the urge to say, well, it's family, I'll try to play, peacemaker. Yes, do that. I do remember that kumbaya is a very good option in these cases. And at the root of it, 9 times out of 10, they're fighting over some Christmas morning that neither of them remember. I, all right, that doesn't change the impact, the financial impact of these squabbles on the welfare, the financial welfare of your ward, because they're bickering back forth and center. Hundreds of thousands of dollars can go out the window before your ward ever gets, the actual service they need or whatever is going on. Now, if they want to squander their inheritance, mazel tov. But while we're involved, we can't really be playing around with that. So speak up. Like you can say, I'm highly recommending this. You can say, yes, Your Honor, I'm trying to negotiate, but I think, I'm trying to play middleman. But at the end of the day, this needs to happen now. That person is wrong. You know what I mean? Don't make legal conclusions, defer to your attorney always, but really speak up, and acknowledge that both sides can be right or can be acting in good faith. If you start with these cases in particular, if you focus everything through the lens of regardless how ridiculous it is, because I guarantee you they're saying the same thing about you. All right, there is more than likely, the chance that both sides believe they're doing the right thing. And if you
Right.
start with that and you let them know that, then you're more likely to get through it. That's a lot better than going through litigation. Um, but understanding case law and is key to that too. So just because a document gets changed doesn't mean it's written in stone. The famous case law that we would rely on is in Ray Carpenter's estate, which we talked about the factors the court would consider in undue influence cases. So that's, they may be capacitated, but now they are reliant on this other person in that position of authority. They, impress upon the person this undue influence. As long as they use it to their self-interest, it can then be reviewable by the court, and you have a lot of power there. But if you're if you're coming in on an emergency basis, it's not the biggest problem. But the use of your authority, obviously, act within the scope of your letters, act within the scope of your orders. When in doubt, ask permission from the judge, especially when it comes to multiple kids fighting. How
Mm.
many cases have everybody here been on when it's more or less the kids fighting over an inheritance when dad is still very much with us? Um, so you can't negotiate that. And it's very easy to fall into that trap. You have to remember what hat you are wearing. And this is in every scenario. If somebody's a power of attorney and a healthcare surrogate and this and that, each one comes with different hats. And if you're the guardian of just the person, maybe stay out of the property lane. But at the same time, remember, as the guardian of the person, you need to know what's going on with the assets and you do have a voice. So navigating that terrain is very, very crucial to get a good outcome. Your attorney can absolutely help you out, but it's always good to stop and step back when the case gets very complicated. Just go, wait, who am I to these people, and who are they to this hat under this case number? And that's it, because that's the only thing the judge cares about. It's, the brother or the stepson is screaming because he wants the person to stay here. Who cares? That's the ex stepson. Why do we? I mean, I'm sure he's a very nice guy. It's not relevant to what we're doing here today. So being able to have that kind of buffer with the court, and maybe they'll be let in or whatever it is. But having that boundary is going to keep a lot of your more contentious cases cleaner.
Okay.
Yeah, make sure to revoke any previous advance directives. They are automatically suspended by your appointment, but make sure everybody knows it. If there are copies out in the world, get them retracted. If there's allegations of the person using them in the past inappropriately, make sure your order says loud and proud, do not recognize these previous ones pending further order. Make sure they get to the banks. Um, and once you really have that level of authority, you're standing in their shoes, you can do really anything that that the court could ask, that you would generally ask for the court. Um, and then you just have to go get that order solidifying that right. If that kind of makes sense. You don't need necessarily permission to do a lot of things. You have to go try to do it and then get the permission later.
Because
But
what happens in the real world is we walk into the bank, we have the freeze order, and they could care less, and
correct.
they don't want to freeze it even though we have it. And so, my habit every single time that happens is to say, okay, Mr. Richard, I'm sitting across from you. You're the bank officer. You're telling me you're not going to honor this freeze order. It is 3:33 on Thursday the 26th. I am writing all this down because if money disappears between now and when I get you to recognize a court's order, you're going to be responsible, and you'll be the one talking to attorney Michael Julian about why you didn't do what you were supposed to do. And sometimes that works, but
Sometimes here's
sometimes, and other times they simply won't honor them. And then we're going back to our attorney, back to the judge, fighting Bank of America, fighting Chase. And it's not
it,
easy.
it is not easy. It is also not, in my experience. I had hair when I graduated law school, by the way. Just for frame of reference, it's not always possible to fight with a bank. It's not even a building. It's not the guy across the table. It is a computer system that will or won't do what the guy tells it to.
Yeah.
I know exactly how infuriating it is to be standing there with a court order and literally poke someone with it and refuse to acknowledge that it's there. Um, don't take it personally. They may be actual robots, who knows? But no, they're gonna stand there and they don't care if they get sued because it's a bank. They print the money. It's a bank. The office is based in almost always Delaware. They have the way they do it. If it does not conform with their system, it will not even go through. Don't bother fighting. It's not worth the time. It's one of those you catch more flies with honey sort of thing. So if you work with the same numbers of banks, kind of get used to what they do and how they handle things. And it's pretty straightforward as long as the order says kind of what they want, how they need it, it'll go through. One of the phrases that I found is Chase is authorized and directed to do X. All right, because you'll have sometimes, all right, Chase is ordered to do X, and then a lawyer over at Chase goes, well, I'm not a party to this case, and you can't tell me to do bupkis until you plead me in. And, maybe I'll show up or not because it's not in my interest to help you. Um, but if it says that they are authorized, A, great, and directed, but not ordered, it's one of those little things that it makes the corporate bugs happy.
Oh, I like that. That's a great word. Okay. That's great.
So, injunction for protection against exploitation. This is an incredibly powerful tool, but it is not for use in all situations. It is not a catch-all for recovery. There are certain judges who do not believe that guardians should use it because you are the guardian already standing in the shoes. But I don't believe that the statute supports that. It does specifically say that a guardian is entitled to bring that action. The question is whether or not the ward or the vulnerable adult is going to be irreparably and immediately harmed, right? This is a break glass type deal. There's money going out of in the accounts in real time. This is the judges don't tend to like it to recover houses, even though if it's an emergency and somebody is about to be kicked out of a nursing home, then this would be an extreme type of relief. But it is enormously powerful. You're more likely to be able to encounter these cases when you're approached by family members concerned with contact. So this is what you might want to consider when family member comes and says, hey, my mom, dad, aunt is now being unduly influenced by this person who has no real authority, and we can see real signs of exploitation, abuse, neglect, something like that. And take your time to sit down with your lawyer and kind of look at, if you're considering it, the amount of things you can do with it, um, because it can also be a double-edged sword, um, and tie you to some other litigation you might not need. But
So am I hearing that if it happened in the past versus the word you said, which was irreparable and immediately,
this is
if it
going
happened,
an
3 months,
injunction
6 months, 9 months ago,
an injunction is to stop something right now. So really
okay,
what it is, you're starting a lawsuit and you're going to the verdict before they even know what's happening. Kind of. So you're going to the court and saying, hey, I need this person thrown out of that house and get a restraining order. And here's all the evidence. And you have to be able to really live up to a high bar for the judge to feel comfortable and say, yes, give it to him. But with that order, you can get it served directly onto the house. Whoever is there needs to get out by tomorrow. You can have orders requiring them to turn over accountings, documents, material, assets, anything under the sun. And violation of that is a crime. It keeps contact away. You can get one later on. If somebody, let's say you get involved, if you're the guardian and somebody is now still pecking at your ward, that's something you can use to get a stay away order. It's a restraining order with some bigger.
right? Because they have a credit card which we're trying to turn off. They have joint access. They're tapping the Wells account every time the $5,000 income comes in from Social Security. The next afternoon they're tapping it out, and
You
that's
can
we're fighting with that.
you can freeze every account and line of credit out there under the sun with this, but be advised you're gonna need to be able to articulate to the judge if this gets granted. I will be able to pay for my ward's fees by this. Like, yes, if we freeze this, I'm going to be able
There's
to,
there's another pot of money somewhere else that I can do it with.
or or the judge can say, say there's X amount here, but we see it getting siphoned off. All right, I'm asking your honor to freeze it and transfer how much here and hold it for us so I can pay bills, whatever is needed. But
Okay.
remember, it's not just, hey, freeze everything and then figure it out later, because you may end up in a situation where now it's a month or two later and you go, oh, wait, now everything's still frozen.
Can't
Um,
pay the facility bill, can't pay the caregivers, all that.
so, yeah, I think that's the second
Okay.
step ahead. And when it's appropriate, this is really one of the most powerful tools that you can have. But if you're already the guardian, it's not likely what you're going to be using to say recover a house. You would be using like an injunction action unless somebody just moved in and claimed it. Or they've been withholding the use of the house for so long that someone is going to be impoverished and thrown out on the street unless unless it's monetized immediately.
Okay.
So, and here we are back to law enforcement again. Evidence can be interpreted different ways. What is black and white to you and me is, many different shades of gray. When it comes to exploitation, I have come to the resignation that if they have the same last name, it's not going to get treated criminally. I don't care how bad it is.
Wow.
Yeah.
Wow.
Not necessarily.
Wow.
So
That's
we
not
have
true.
a question in the
Incredibly.
chat real quick. Diana wants to know, how do we get banks to understand that encouraging family to do joint accounts to have better access to pay bills and avoid probate? So how do we get banks to understand that encouraging family to do joint accounts to have better access to pay bills and avoid probate? Question mark. The joint accounts are a bad idea. So Diana
I
wants to know, how do we get banks to understand that's a bad idea?
I mean, it depends on the situation. In some instances, it's a very important estate planning tool to have that
Yeah.
joint account,
Yeah. Yeah.
to bypass probate and to have that ease of access to funds. You're basically putting a lot of faith into the person you're putting on an account. The bank is going to be governed by just their standard fiduciary interests, but you can, if you want to put pressure on them and start threatening them, with allegations of some negligent oversight, very often when you get into these cases, hey, send out that subpoena. Hey, I want to know everything that was going on. I want to know where the card was issued. I want the signature statements. I want the ATM and the audio so I can hear all this and I can see that person using the card and I can see that signature statement when it's a bad idea. But when it comes to talking to the banks to change their policy, good luck.
I think the banks do this for lots of reasons. One is they are truly trying to help their clients a lot. The other is they just want somebody on that account besides the demented grandma. They're happy to have anybody, no matter how bad they are. And that's the catch-22, Diana. I don't think we can fix this because it's in the best interest of the banks most of the time for there to be someone else on the account. That's the problem. Even the bad guy.
Yeah. But
Yeah.
again, that comes back to the same thing if somebody's on that account. Florida, again, title state, they're on the title. They have technical right to the property until you go to enforce your claim. But if somebody is added to an account with a vulnerable adult, or a ward or whatever reason that you're coming into the situation, odds are they're pretty well aware or should be aware that these funds are to be used for an appropriate purpose. And as long as you document the evidence appropriately, right? That's what comes in key. It's not just the statement, but what does it go with? So what? He took him to a roller coaster. Well, grandpa, can't walk. He obviously didn't go to the thing. I want to talk about documenting communication efforts early when it comes to family member dynamics, because this is coming up now. When you're dealing with a bunch of family members talking about, hey, I can't get in contact with someone, or you're talking about, hey, I can't get in contact with my ward or this reporter, whatever it is. You need to have context with what you're showing someone. So even if you have two kids and a stepmom, an evil stepmom, holding whatever dad, and they all have text messages with dad saying, I'm going to come over and visit, I'm going to come over and visit, or they're just talking on the phone. When you go to show that to a judge or a cop, they see missed call, whatever, whatever that is, you need to kind of have context. So group chats I found to be a great way to do it. And I want you to think of like a radio protocol. If anybody's ever kind of played around with those things, this is over, under, whatever, that old Leslie Nielsen skit. Hey, Dad, it's Billy and Susie. We want to come see you tomorrow. Dad, I know you can't, we just talked on the phone, but I want you to be able to see it when you wake up. And that way you have multiple phones going to the same text chain, and it doesn't matter if evil stepmom responds or not. Because how many times do you see, well, I tried to coordinate this visit with dad, but evil stepmom, didn't put it together at the last minute, or dad canceled last minute. No, this has everybody kind of on notice. When they make that phone call, um, hey dad, I'm going to call and bring over some coffee and donuts, hang up the phone, great talking to you, see you tomorrow with coffee and donuts. Then when you get there and they don't let you in, hey, what happened, dad? Are you okay? Nobody's answering the phone, text, and all of a sudden you have grounds for that med intervention potentially, or
Ah,
because you have
perfect.
documented proof
Perfect.
that got canceled with no explanation. You see what I'm saying?
Yeah. So, because like what we're stuck with a lot of these folks, they don't want to email us. They don't want to do any paper trail. So what I'm more often stuck with is right after the call, I can send this is a good idea, because now I can send a text to the group text and say, hey, just got off the phone with Joey. He says he's going to go take Dad's spaghetti dinner tomorrow night at 7, just so everybody is aware. That's perfect, because then you can document the phone conversation. Everybody else knows about it. And when he pulls some stunt, I like that. I had not thought about that. That's helpful.
If anybody has a particularly contentious family cluster mess, consider tools that are available in custody proceedings. My Family Wizard. I'm sure somebody out there is having a flashback right now. It could be an incredibly valuable tool to make sure everybody is on their best behavior when it comes to coordinating visits. But again, it doesn't matter what it is. Like I've seen it, all the time where someone's like, "Yeah, I took so and so on vacation. This is great." It's like, I don't think Grandma's skiing the Alps. All right, it's very nice you took her, but you just paid off your credit card bill with the extra $20 from the Publix you took over the past 3 months, and here's the spreadsheet. So,
Michael, I have one question that we missed in the banking conversation a few seconds ago. Is there really such a thing as adding to someone to your account for convenience? Is that even real?
yeah, just a signer only. So if you're on an account, when you start investigating what's going on with an account, don't rely on the statements alone. Just because the statement has the name or whatever, you want to look at the signature card. It's usually called used to be, or the contract pack. But basically, whatever somebody signed on, that is going to establish the legal relationship that they now have with the account. And that's going to dictate the legal authority and all that good stuff. But even regardless, you still have the catch-all of known or should have known that the person was in a vulnerable state or that these were to be used for their care. So basically, if they're on an account and you guys are involved, they probably did something they shouldn't have or need to just at least account for. But
Okay.
again,
All right.
always consider the cost benefit analysis of how much you might be going after. Is the juice worth the squeeze? Because you could end up very quickly bogged
Okay. All right, let's keep going because
down. We're gonna
Michael and I can get seriously bogged down.
Yeah,
so
Robin made a comment and she said she had law enforcement blaming her for how her ward was acting. And then Diana wants to know, how do you keep your presence and the person you are concerned with actually keeping the conversation on chat? What if the family refuses to add the guardian to the group chat?
oh, you get a court order. Yeah, you shall communicate X way or show cause as to why you shall not be held in contempt of court. And we'll do it on a Friday afternoon, and you better have a good answer, or I'll see you Monday. I
Okay.
mean, judges won't do that. But again, like it depends on who your judge is. If you get it in an order, it should be followed. If it's not getting followed, they better have an excuse, or very seriously, yeah, they could be spending the night somewhere that's less comfortable than usual. Um, but whatever, if you're just the refusing to utilize a service like that is automatically going to paint them as a bad guy. They're going to have no more credibility, and until you get on that chat, you don't have a voice, essentially.
Okay.
Uh,
Good idea.
yeah, I'm going to
And
start
I think
using.
what you do is you start that in the beginning before the crap hits the fan. Like the day you get appointed, you get everybody's cell phone numbers and you say, "Hey, I'm so glad to know about all you guys. I've created a group chat for all of us so we can all know what's happening for mom. And this is the best way for us to communicate." And that's
It's
before the war starts.
Yeah, actually, now that you're saying that, I really think I'm going to work that into my normal practice going forward. When someone gets appointed to a contested case, the order will say the family shall communicate on whatever the issue is, a group email. So
Perfect.
it shall be subject to disclosure and no
Perfect.
conflict. It's good.
Perfect.
So presenting evidence, again, you have to meet the law enforcement where they are. If you are complaining to a roadie, he's not going to be able to help you enforce an order. If you have an order to get access, it needs to be served by the service unit, and it's going to be enforced by a different unit more often than not. And calling ahead and coordinating that makes it go a lot smoother. No one piece of information is relevant to anything until it has a corresponding piece of information that makes it relevant. So that's the spending is not in and of itself isn't inappropriate unless the person can't consent. Or, I paid off his bills, but I was eating all this or whatever. He didn't come to lunch for the 15th time in a row. Bringing that all to the table and having documentation of both things is going to save you a lot of headache. Take the time, now that I'm thinking about it, to look at if you're accusing somebody of something, pull up the statute. Just Google, Florida statute, exploitation, and it's going to give you the technical definition. And if you just break it it comes in an A, B, C. You're going to have a piece of evidence that ties to this, that ties to that. So the classic example is, drunk driving. You have to be driving a car while under the influence of a substance to the extent that your faculties are impaired. And then you have to prove 1, 2, 3, and just say, this is how, this is how, this is how. Once you do that, you put it in front of a lawyer, a cop, or something, and hopefully they'll know what to do with it.
Okay.
We are all familiar with these best practices. Start fast, start loud. The louder you are, the earlier you are, the quicker people are going to know you mean business. wards die waiting for hearings. I
Absolutely.
I would
Absolutely.
avoid getting too nitty-gritty arguing with lawyers about details in orders to resolve like emergency issues. You run the risk of looking like you're not necessarily looking out for the best interest of the ward, but defer to your lawyer. Um, and yeah, detail. Try keeping this material together when you smell smoke is so much easier than putting it together after the fact. And I really can't overstress that enough. So if you just have good general practices and good note-taking habits on all your cases, when it comes to something like something problematic coming up, you just know, okay, I called here. This is why, I had that feeling and I saved everything to this folder. Here you go.
Michael, I kind of like the minute I start getting my spidey senses feeling that way, I tend to start a word bullet point document just because it's where I like to hold it. And I say, on this date, this happened. On this date, I found this, and then this, and then this. And then I
Yeah.
send it to the attorney, and I'm like, okay, I'm beginning to feel this is sketchy. Here's the 7 things that I know, and this is only 2 days in. And then my attorney and I start talking about whether how far we're going to push with this because we still got tons of information that we don't yet have, but it's starting to feel bad enough that I want the attorney to start thinking, here's what I know, or I think I know.
Yes.
Here, and then the next time I send them the bullet point, it's got 7 or 8 more issues, and now we're like, okay, we're absolutely there. We don't need to wait another 3 or 4 days. We need to move, and I find that helps me follow along and not get too far into the weeds because if I start talking about the fact that all the other problems with the ward, that doesn't really help. My attorney needs to hear about the exploitation, the abuse, and neglect, and not the other stuff at that point. So that's how I do it. I keep a running Word document, and then eventually, when it starts getting deep for law enforcement, then I blow up each one of those bullet points with all the
So
attachments.
I've had now multiple times where I or somebody else on a case or whatever, like we get to halfway, endpoint, whatever, and we're like, how did I miss that? How did I not put it together? And it happened a few times before I realized, well, you can't put pieces together until there are pieces to put together. Sounds sounds very simple, but again, not everything happens all at once. First one thing,
Right.
then another, then a pattern, then a picture.
Yeah.
So if you're racking your brain for like, wait, he told me he was going to meet me, and then he, didn't call, and then he told me like those little weird things in how somebody sets up a appointment where you're like, this dude is running me around. You
Right.
can't articulate that a month from now unless you have, on this moment he texts or whatever. So keep those notes. Um, some of those things pay off in just absolutely hilarious and spectacular ways. So far down. Yeah, so early detection, obviously early notation, early when you notice it, say something, see something, say something. Um, Civil and criminal remedies. One of the my favorite things to do is if you're a guardian on a case and someone's been taken advantage of, a lot of times the lawyers will struggle to find what to sue someone for.
Right.
You're in luck. Florida has a catch-all statute for just crime and civil penalties. So it takes the standard beyond reasonable doubt bar and drops it way lower. So I think I don't remember. It's not preponderance. Um, it's a much lower standard and it allows you to recover damages just under the application of the criminal statute. So it's that simplified, um, you know, they were drunk, they were driving at the same time, boom. And if you could do that on, all right, you had a power of attorney, you spent it on a Ferrari, and that wasn't in his best interest, boom, you're good. And you can apply it the same way. Makes your lawyer's life a lot easier and makes these things a lot easier to kind of think about how to develop your evidence and develop your case. So if you're thinking about it that way, how would you prove a bank fraud case, right? Well, send a subpoena, and if you got this, if you have their location when some of these things are done, it's very useful to.
So Michael, one of the struggles I had early on in my career, because these cases made me so crazy that I would go after them. This was before 825 existed. And I would go after them and spend stupid amounts of hours doing anything I possibly could to basically spoon feed everything to law enforcement to try to get them to do something. And the problem is most of those cases are unrecoverable. My case that bothers me the worst was a guy who was a crackhead, and he was the lawn man stealing from my ward to the tune of 200 and something $1,000. And the thing is that I was trying to, in time, learn to balance the difference between how much time that I'm charging to the ward for my time and my attorney's time on money we are not going to recover. But the other side of me says, I want this guy in jail, even if we don't recover a dime. So what are some ways we can balance that when we don't believe for a second there's a dime to recover? What do we do?
So the injunction is a good option. You have someone that is coming into contact regularly with your ward, and there's money going out the door. There's no reasonable contact. You believe that there's ongoing risk of exploitation if injunctive relief is not provided. Get an injunction, and under the injunction, you can be ordered to pay. I mean, at a certain point, the courts, at a certain point, there is a very real cost benefit consideration to these
I'm
things.
sorry. Yeah, but okay, I get that. Ordered to pay, he's a crackhead. So I hear you. Sure, he's
Well, so
ordered to pay.
if he comes back around, he gets arrested.
Okay.
So a function is a restraining order, regular old restraining order, just with some bigger teeth.
Okay.
Is we got any more questions? Strange scenarios?
We do. So Diana wants to know, when the judge's caseloads are high and the hearing dates are getting farther away, how do you get this case you feel is an emergency now to be heard now or real soon?
Okay. I don't anymore unless if they're bleeding, break glass. Um, if you believe it's an emergency, remember you guys got more often than not, if you got appointed, you got brought in by the court. So don't be afraid to stand up. I will say that attorneys are taking hits because we will come in as an emergency and it's a major interruption to the judge's docket. When I say major interruption, that's not like an inconvenience sort of thing. They're not grumpy because it's rude. It is a real problem sometimes. And a lot of times, what we consider to be an emergency when we file it, by the time we get it in front of the judge, isn't necessary. It isn't necessarily an emergency by then. And it was just, strongly urged to me that something has to be emergent for it to be an emergency. Is there something happening right now that only I in this world can stop? Being the judge, that then you file as an emergency, and they will move mountains to give you anything they can legally. If it's anything less than that, you may not be well received. But again, everybody's here for your ward. And when it comes to just moving things along on the court's docket, the court is the court is the court. We need more judges. We need more courts. Buy the J.A. Flowers.
Well, there you go.
Well, no,
So,
actually, let me back up. Let me back up. If you are very clear up front, if you have a good relationship with the JA or your lawyer, if your lawyer's paralegal has a good relationship with the JA specifically, and you have an issue that's very urgent, it's going to impact, some serious well-being, but it's not emergency. You can play those violins on the phone and work some magic, and that's just a skill set.
great. So there you go, Diana. That's some tips and tricks there. A couple people have asked in the chat about how you can get a copy of this recording. Kate will send all of that out to everybody. Usually takes her a day or two, but this is being recorded. So Robin, I see that you were on the phone and you didn't get to listen to a lot of this. We do have this recorded. Kate will get it sent out to you guys. Rebecca wants to know what your thoughts are on a forensics accounting to go back a few years to gain data of proof of theft. Is that a waste of time? Does it benefit the ward who lost money, and can you get it back?
Think about excellent question. Excellent question. Think about what a forensic accounting is. All right. It's basically just a bookkeeping with some opinion, right? It's a little more detailed. Whether or not it's going to be worth it is going to be talking about the amount of money that's at play. you can probably do a fairly detailed accounting that you can testify to yourself. When you are the guardian, you are the custodian of the ward's records. You can compile your own accounting, and you can work with a bookkeeper or your regular accountant to just do a summary of these things, and that sort of thing. If forensic accounting might not be necessary unless you're trying to really track down fraudulent intent within like multiple revenue streams. So, like if you have a trust and a business and some rental properties and they move stuff around and then they lend money to themselves, yes, get a forensic accountant. My mom happens to be one of the better ones in the business. She got a forensic accounting degree when she was bored after being a judge. Um, but a lot of this stuff you can do yourself. A lot of it's common sense. Just make a spreadsheet and you can argue about it. But if you're looking for fraud in the past, look for patterns. Did they change drastically when someone came into the picture?
Other questions, Julie?
Rebecca said thank you. Not so much questions. Amanda said she had a comment. She said, in her experience, law enforcement often turns a blind eye. So that was her comment.
You're working with
Yeah, and I think that does happen, but I've found that the more I connect with them in advance and show them what's going on, specifically the sheriff. Remember, you really have to understand, sheriff and city police they're not the same characters at all. So
Well, it's
kind of
not that it's different hats, different jurisdictions. The sheriff is going to carry out court orders. If you're accusing someone, so let's talk about law enforcement with two different things: dealing with law enforcement to carry out a court instruction, and dealing with law enforcement to conduct an investigation. All right. If you're making an accusation, let's consider this is actually a really big one. And I know we're going a little long, but let's consider what DCFAPS is for, what law enforcement is for, and what we can do. So a lot of people think, okay, that person's being exploited. I'm going to call Adult Protective Services, and they go out and they don't get a callback or whatever. APS is there to do very basic investigation. Is this person in need of help, services, and can they not, consent to it? And if they're not interested, which most grumpy old, grandpas are not interested in, they're going to tell this dude the same thing he told the mailman, the same he told everybody else. They're going to say yes. He can consent, and he doesn't. So don't take that as a indication that somebody wasn't exploited. Don't let someone else take that as a conclusion that someone isn't being exploited. Law enforcement is going to do a welfare check. What is a welfare check? Knock, knock. Who's there? Still breathing? Bye. Unless they're bleeding, being tied to a chair or something, unless it's really obvious that someone's in distress, they are not going to enter into that property or do anything that they would need a warrant for. But you guys, when you're appointed guardian, you now get to make the accusation that he stole something, that he did this. By you saying it was wrong, it becomes the crime. So now you can start going to investigators and authority figures making those types of allegations when you couldn't before.
right. The other thing I'm finding is lots of county sheriff's department actually have an elder abuse department, and many times they are really helpful because they are in that department because they have like a personal passion. So I've found that if you can find that person in the sheriff's department that deals with elder abuse, exploitation, and neglect, and you start developing a relationship with them, then when
Yeah.
something happens, they know that you're one of the good guys. That's part of the problem. They don't know any more that you're a good guy than the daughter is. That's part of the problem.
Departments, and so when you're trying to do this criminally, you're dealing with law enforcement as one, and then like the state attorneys or the federal authorities, whatever, the prosecuting authority. Prosecutors' offices have a lot of turnaround. Judge, I did not realize how fast these detectives I've been working with were turning over. It's nobody's fault. It's the department. They got the manpower they got. But if you are not familiar with these concepts, even if you're a great cop, you are not going to know what you're looking at. Case in point, I had a DCF investigator, 20-year veteran, very good investigator, but he was very early in this phase of his career and didn't quite understand what he was being called out to investigate, right? So just because there's an allegation that, hey, she put herself on the deed X amount of years ago and blah, 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 and now all this other bad stuff is happening, thanks to now that all this bad stuff is happening, the investigator might go and think, oh, I'm just here about that deed. No, 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 no. We're about the casino. We're about the all the other stuff, and up here, not back there. And don't be surprised if after your investigation results come out, you find out that somebody was investigating a problem you didn't even. You know what I mean? It's very strange, but that's why
Yeah.
staying involved and guiding these things are important.
So Amanda says she had a daughter who stole so much money from her father, and she has the documentation. She has a forensic accounting. She turned over the evidence to financial detectives, and she's had no response. It's been about 2 years.
Yeah,
Amanda, are you up there? But
so let me ask you this. Is dad on and this is hypothetical, this is not to this case, don't ask me, don't give me any real answer, but the consideration would be, daughter steals from dad and dad is sick, dying, isn't this terrible? Okay, is dad going to be kicked out of where he is? Is he going to be materially deprived? Is he going to lose the care he has if we don't recover these funds? Right? Basically, if I don't act, is something bad going to happen to this dude that otherwise wouldn't? Because let's say, and I swear this is the same math I hear constantly, is well, let's say I get it back and he dies the next day, it goes to her, right? So, and I know now that doesn't mean you're the guardian, you have the authority, you are ordered and empowered, and you've been put there by the court to marshal assets, and you are expected to follow your orders. But before you initiate litigation, you also have to get leave of court. You have to explain why this has to be turned over. And I've been deflated more times than once when I've been told by a judge, yeah, they did it, but you think they want to throw their own kid in prison?
because he says it's going to become hers anyway.
Well, no, I mean, like, I don't have a kid. I have a dog. He could bite my face off, and I wouldn't be mad at him.
Wow.
I guess there's a lot of people who wouldn't be that mad if they.
Yeah. Yeah. Okay. All right. I'm looking now. I can see the chats for some reason.
So
I'm
yeah,
looking.
we're getting a lot of people saying thank you. It's really good
Oh,
information. They needed that. Oh, and Amanda chimed back in. She said, "Oh no, there's enough money left to care for him, but thank you for the answer."
I'm really
That
glad
makes
that
okay.
there's a.
So everybody, I want you to take Michael's information, because just so you know, unless your attorney is really good at this injunction stuff, you might want to consider using Michael, where your
So
attorney and
the
Michael
injunction
team together. And I'm
is
not doing this from a marketing point of view. I just want to say, I know a lot of attorneys don't really know how this works, and Michael does. So keep his contact information, because when you have these cases and you feel like your attorney either doesn't know, or maybe needs some support, maybe Michael's the guy. And I'm not doing this to marketing for him. I'm doing it so you have a resource.
No, I appreciate that. And 90% of the stuff I talked about, your standard lawyers can absolutely do if they just know where to look,
Right.
especially if you're in these guardianship divisions, it's the same judges, same lawyers. I guarantee you, they're like, man, I have something, I just can't figure out what vehicle to use, is what they might say. And then I probably got a template somewhere I can bounce them.
Nice.
Yeah,
Nice. Nice.
but I
And
love working with you guys.
just
I
for
love it.
everybody who's still online, this is a little sneaky conversation. With any luck at all, Michael and I and some other folks together are going to work on a project where we actually start educating the sheriff's departments all around the state, so that you won't struggle so much. So that's kind of on our 2026, 2027 schedule, because if they knew what to do and they would willingly support you, maybe things will go better. So that is in Michael and I've been talking about that. It's a long way out, but we do understand that they don't have many law enforcement folks don't have the training that if they had would make this go better. So we kind of have that in our pile of things to work on. We know it's a problem and we know it needs to get addressed. So we're trying to accomplish that. So look forward to that in the future, hopefully.
So Diana's asking for Michael's contact info. I happen to know he dropped it in the chat, but we will also make sure Kate gets it out to you guys when she sends out the information so you have it.
Oh, I thought everybody could see the chat.
They might if they click on the chat, but
Oh,
Michael did drop it in the chat.
I can put my email in here too.
Okay.
Yeah,
But
that's
yeah, if
helpful.
you don't mind, Michael, we'll include it in the information we send out, and then that way they have it.
Not a problem at all.
There you
Awesome.
go.
Perfect.
His phone number and his email. Okay, guys. So we did good. We're gonna wrap this up at about 4:10. Big reminder for everyone: if you haven't taken AGID's GSI class in Longwood, Florida, it's a whole day. The next class is the 12th of March coming up. If you are, especially if you're a newer guardian, try to do it. It's very inexpensive. It's $50 plus you get lunch. It's the whole day. It's very unique training. It's really, really, really worth it because you will walk away as if you had new cases and know what the heck to do. So looking for GSI on the AGID website or in our peer group, or give me a call or give Kate a call. There we go. The girls just put it up in the chat.
Yeah, I just dropped it in the chat too.
Thank you. It's really special training, and I want everybody to take it at least once. All right, guys, are we good?
Yeah, everybody's thanking Michael. Thank you, Michael. It's been a fantastic presentation. Everybody
Thank
got a
you.
lot of good info from you. So
I
thank you.
appreciate it. It was
Thank you,
blessed.
Michael. We'll talk again. All right.
Bye.
Bye, everybody.